Do you have a U.S. green card? Or did you enter America as a refugee? Then listen up, this could affect you directly. Under a shocking new order from Donald Trump, the green card processing for over 235,000 refugees has been completely frozen, indefinitely. And starting right now in March 2026, a massive nationwide re-interview operation is expanding across the United States. In today's video, I'll break down exactly who's at risk of having their status revoked or detained, and who needs to contact an immigration lawyer immediately. Don't skip this. Watching till the end could save you or your family from major trouble. Welcome back. If you are a refugee who came to the United States between January 20th, 2021 and February 20th, 2025, the period of the Biden administration, what is happening right now in the American immigration system directly affects your life, your family, and your future. My name is Via, and today we are breaking down one of the most consequential immigration crackdowns in modern American history. We are talking about a full federal freeze on green card processing for hundreds of thousands of people who followed every rule, waited years in camps abroad, passed every background check, and were legally admitted to this country. And yet, as of today, March 2026, their path to permanent residency has been stopped cold. Let us start from the beginning so everyone watching fully understands how we got here. On November 21st, 2025, a memo signed by Joseph Edlow, the Director of U.S. Citizenship and Immigration Services, known as USCIS, set off alarm bells across the entire American refugee and immigration community. That memo, which was obtained and reviewed by multiple major news organizations, including the Associated Press and NBC News, announced that the Trump administration was ordering a comprehensive review and mandatory re-interview of every single refugee admitted to the United States during the Biden administration years. Every single one. The memo stated that the Biden administration had prioritized, in its own words, quote, expediency and quantity over, quote, detailed screening and vetting. Based on that claim, the Trump administration said it had no choice but to reopen and re-examine every one of those cases. Now, how many people are we actually talking about? According to reporting by the Associated Press and confirmed by multiple immigration policy organizations, approximately 235,000 refugees are caught up in this freeze and review process. These are people who came legally through one of the most rigorous vetting systems in the entire world. Refugee applicants typically wait 1 to 2 years overseas before they are even approved for travel. They undergo medical examinations, biometric screenings, in-depth background checks conducted by the FBI and other national security agencies, and multiple rounds of interviews. Advocates for the refugee program were quick to point out that refugees are, consistently, among the most thoroughly vetted group of individuals who ever enter the United States. And yet, the Trump administration's November 2025 memo essentially declared all of that prior vetting insufficient. What does the freeze actually mean for individuals on the ground? First, and most critically, all pending Form I-485 applications, that is the official green card application, filed by refugees admitted between January 20th, 2021 and February 20th, 2025, have been placed on hold, immediately and indefinitely. If you filed your green card application, paid your fees, attended your biometrics appointment, and were waiting for a decision, that decision is now frozen. You are in a legal limbo with no clear end date in sight. Second, even refugees who have already received green cards are not fully safe. The memo makes clear that the administration retains the authority to review and potentially revoke refugee status, even for those who have already adjusted to lawful permanent resident status. That is an extraordinary and deeply alarming position that immigration attorneys across the country say is legally unprecedented in its scope. Third, and this is where the situation escalated dramatically, the administration moved beyond paperwork freezes and into active enforcement operations. On January 9th, 2026, the Department of Homeland Security and USCIS jointly announced the launch of Operation PARRIS. That name is an acronym. It stands for Post-Admission Refugee Re-Verification and Integrity Strengthening. The stated initial focus of Operation PARRIS was approximately 5,600 refugees living in the state of Minnesota who had not yet received their green cards. Why Minnesota? The Department of Homeland Security described Minnesota as, in their own words, quote, ground zero for the war on fraud, citing an earlier investigation called Operation Twin Shield, which they claimed uncovered immigration fraud connected to public benefit programs. Minnesota has one of the largest Somali refugee communities in the entire United States, and immigration attorneys and civil rights organizations immediately pointed out what they described as a disturbing pattern of racial and religious targeting embedded in the operation. What happened next shocked the nation. Beginning in January 2026, federal immigration agents fanned out across Minnesota cities. Families described agents arriving at their front doors at dawn, guns drawn. Others described being pulled over while driving to work or to buy groceries. Attorneys reported that at least 150 refugees were arrested during the initial weeks of Operation PARRIS. Many were handcuffed, transported to the Whipple Federal Building at Fort Snelling in Minneapolis, and then, before their families could locate them or attorneys could file legal petitions on their behalf, flown to detention centers deep in Texas. Some families had no idea where their relatives had been taken for days. One immigration attorney in Minnesota, Jonah Munoz, described the case of an Eritrean single mother of 3. She had a pending green card application when agents arrested her. During a 5-hour re-interview, the USCIS officer conducting the session told her attorney that he had no idea why she was even there and that he had no authority over her detention. Her green card application was ultimately approved while she sat in a detention facility hundreds of miles from her children. She was eventually released and returned home. These stories are not isolated. They represent the human cost of a sweeping federal policy that legal experts say has no clear basis in decades of established refugee and immigration law. On January 28, 2026, U.S. District Court Judge John Tunheim, a federal judge in Minnesota, intervened. He issued a temporary restraining order halting the arrests and detentions of Minnesota refugees under Operation PARRIS. In his order, Judge Tunheim wrote with unmistakable directness. He stated that refugees have a legal right to be in the United States, a right to work, a right to live peacefully, and importantly, a right not to be subjected to the terror of being arrested and detained without warrants or cause in their homes or on their way to religious services or to buy groceries. The court concluded that federal statutes governing refugees and immigrant detention do not permit prolonged detention of unadjusted refugees who have not been charged with any ground of removability. But the Trump administration did not simply accept that ruling. On February 18, 2026, just before a scheduled court hearing, the Department of Homeland Security filed a new policy memo in the Minnesota federal court. That memo dramatically escalated the government's legal position, claiming that refugees who had not yet received green cards were now subject to mandatory detention by ICE while their status was being reviewed. In other words, the government was arguing that roughly 96,500 refugees with pending green card applications nationwide, not just in Minnesota, could be arrested and held in custody for the entire duration of the review process, which can take 12 months or more even under normal circumstances. Immigration attorney Lori Ball Cooper, Vice President of U.S. Legal Programs at the International Refugee Assistance Project, called the February 18th memo, in her words, a totally contorted reading of the statute and a broad and concerted effort to strip refugees of their legal status and render them deportable. On February 27, 2026, just days ago, Judge Tunheim responded again, this time issuing a broader preliminary injunction. This extended legal protection blocks the government from arresting or detaining Minnesota refugees based solely on their unadjusted status for the full duration of the court case while it plays out. The judge was explicit in his criticism of the government's actions, stating he would not allow federal authorities to use a new and erroneous statutory interpretation to terrorize refugees who immigrated to this country under the promise that they would be welcomed and allowed to live in peace. It is important to be clear about what this court ruling does and does not do. The preliminary injunction issued on February 27, 2026, currently protects refugees in the state of Minnesota from warrantless arrest and detention. It does not end the green card freeze for the 235,000 refugees nationwide. It does not stop USCIS from conducting re-interviews. And critically, the court itself stated that USCIS may continue its statutory process of re-examining refugee green card applications. The fight over detention has been temporarily won in one state. The larger policy battle is still fully underway. Separately, for people from the 19 countries covered under the Trump administration's travel ban, which includes nations such as Afghanistan, Iran, Libya, Somalia, Sudan, Syria, and Yemen, among others, a December 2025 USCIS memo paused all pending applications for green cards, citizenship, and asylum. That freeze covers potentially hundreds of thousands of additional cases beyond the refugee-specific freeze. So who exactly is at risk right now, and what should you do? If you were admitted to the United States as a refugee between January 20th, 2021 and February 20th, 2025, and you have not yet received your green card, you are in the highest risk category under the current environment. Your pending Form I-485 application is frozen. Operation PARRIS has expanded beyond Minnesota. The government's own February 18th memo made clear that operations are not limited to one state. Reports have already emerged of enforcement actions in Maine and other states with significant refugee communities. The Minnesota court injunction does not protect you if you live outside Minnesota. If you were admitted as a refugee during the same period, and you have already received your green card, your situation is more secure legally. But the administration's stated position is that even green card holders can be subject to review. Immigration attorneys advise that green card holders in this category should also seek legal consultation, particularly if they travel internationally or renew documents. If you are a national of one of the 19 travel ban countries and you have any pending immigration application, green card, citizenship, or asylum, your case is frozen under a separate USCIS memo, and you should seek legal counsel immediately. There are several things every affected person should know about their rights right now. You have the right to remain silent during any encounter with immigration officers. You are not required to answer questions about your immigration history without an attorney present. If agents come to your home, you are not required to open the door unless they have a signed judicial warrant, and you can ask to see that warrant through the door before opening it. If you are detained, you have the right to contact an attorney. You have the right to refuse to sign any document without your attorney present. Multiple immigration attorneys have reported that refugees in detention have been pressured to sign voluntary departure or self-deportation documents. Do not sign anything without legal counsel. You should gather and secure all your original immigration documents immediately. This includes your refugee travel document, your I-940 form, your I-485 receipt notice, any employment authorization cards, and any court notices or USCIS correspondence. Keep copies in a second secure location, and if possible, provide a trusted family member or friend with access to those copies. Contact an immigration attorney as soon as possible. Free or low-cost legal resources are available through organizations including the International Refugee Assistance Project, known as IRAP, the Advocates for Human Rights, the American Immigration Lawyers Association, and numerous regional refugee resettlement agencies. Do not wait until you receive a notice or a re-interview letter to seek legal advice. In the current environment, proactive legal consultation is essential. Now let us address the bigger picture, because this story is not just about paperwork. It is about a fundamental shift in how the United States government views its obligations to people it invited here. Under the Refugee Act of 1980, legislation that has governed American refugee policy for over 4 decades across administrations of both political parties, refugees who are admitted to the United States are entitled to a defined legal pathway. They may apply for lawful permanent residency after 1 year in the country. That is the law. For 46 years, refugees went through that process without the threat of warrantless arrest or mandatory detention simply because their green card application was still pending. Operation PARRIS attempted to overturn that 46-year practice by executive memo alone. Federal courts, at least so far, have pushed back hard. Advocacy organizations representing over 80 groups sent a letter to the United States Congress in early 2026, urging lawmakers to terminate Operation PARRIS and restore proper legal process for refugee communities. Elected officials, including Senator Tina Smith and Representative Ilhan Omar of Minnesota, have publicly condemned the operation, calling it a violation of basic due process and American values. Meanwhile, the broader refugee admissions program tells an equally striking story. In fiscal year 2025, 38,000 refugees were resettled into the United States. For fiscal year 2026, the Trump administration set the refugee admissions ceiling at just 7,500, the lowest number since the Refugee Act was enacted in 1980. The administration has designated the majority of those limited spots for Afrikaners, white South Africans, a priority that has drawn significant criticism and legal scrutiny. Here is the bottom line as of March 2026. The green card freeze for approximately 235,000 Biden-era refugees remains fully in effect nationwide. Operation PARRIS re-interviews are continuing, even in Minnesota, where the court clarified that USCIS may still conduct interviews without conducting warrantless arrests. The government's February 18th memo signals a clear intention to expand detention operations nationally for refugees without green cards. The preliminary injunction in Minnesota is the strongest legal protection currently in place, but it applies only to that state and only for the duration of ongoing litigation. The nationwide situation remains fluid, legally contested, and deeply uncertain. If you or someone in your family is in any of the categories we discussed today, please do not wait. The legal landscape is moving fast, and your window to prepare and protect yourself is now. Share this video with every member of your community who needs to see it. Subscribe for ongoing updates as court rulings and policy changes develop. And most importantly, speak to an immigration attorney. Not next week, today. This has been a breakdown of one of the most consequential immigration stories in America right now. Stay informed, know your rights, and stay safe.